Hello and welcome to On Point. I'm Saldana. For decades, a federal law known as Title IX has governed how schools, colleges, and universities are supposed to handle sexual assaults on campus. But in August, Education Secretary Betsy DeVos imposed a new set of rules for schools to follow in carrying out that law. The changes are controversial. Women's rights groups argue the new rules will be too easy on the accused of sexual assaults. But DeVos defenders say the old Obama-era rules push schools to find students guilty. The new rule provides a process that gives the accused the rights to a live hearing. The accuser will have to face the accused when they give testimony, and those accused will be able to cross-examine their accusers, which was not allowed before. These new rules also raises the burden of proof accusers will have to meet. This will make it harder to prove wrongdoing by the accused. Sexual assaults continue to be one of the major issues on school campuses. According to the Center for Disease Control and Prevention, 1 of 5 women have experienced completed or attempted rape during her lifetime. A sexual assault advocacy group called RAIN says on college campuses, sexual violence is more prevalent than other crimes. On Point's Jessica Vaughan has more on the story.
Thank you, Brenda. We're here today with Deputy Director of CSUN's Equity and Diversity Office, Samuel Richman, Danielle Samuel, CSUN's Campus Care Advocate, and Jenna Parker, partner at HATHAWAY Parker Law Firm in Los Angeles. So we heard in the opening a few statistics about how common sexual assault is. Samuel, I'd like to start with you. How big of a problem is sexual assault for colleges and universities?
Thank you. I know that we've seen varying statistics. It's hard to put exact numbers on the number of students who experience sexual violence while a student in higher education, because sexual violence is incredibly underreported. But recent studies have suggested the number is around 1 in 3 women experience sexual misconduct while in higher education.
And then what is the process on campus when a student alleges sexual assault?
The process on campus for students who allege sexual misconduct depends on who they allege sexual misconduct against, whether it's a faculty member, whether it's a non-CSUN member, or whether it's another student, and the context in which the sexual misconduct occurred. But in all cases, we follow a similar protocol, which is first of all, we always offer resources. No matter whether the student wants to participate in an investigation, we always offer resources, one of which I'm glad that Danielle is part of this, is Strength United, Campus Care Advocates. They're an amazing survivor advocacy group. We're not advocates. We are neutral third-party investigators. We connect them to advocates if they'd like, counseling services, academic accommodations, that sort of thing. And then if the student wants to participate in an investigation, we determine under what process the investigation will take place. Some of those processes involve hearings. And then we issue a formal investigation complaint, investigate, and then resolve the matter either in a hearing with a third party outside hearing officer, or draft a final investigation report ourselves.
And then Danielle, do you think universities are doing enough to assist and provide resources for students who've been sexually assaulted?
I think at California State University Northridge, specifically at CSUN, I think that we are very well connected to different partners on the campus. Campus Care Advocates make it a mission so that we are connected to the Department of Police Services, we're connected to the CLOT Center, we're connected to Title IX. And so no matter which avenue a student decides to go to, that somehow they're able to connect to resources, or at least go to the place that know the resources. So I do think that we are doing a good job in terms of educating the campus of the resources. Once again, there's always more that we can do, and that's always, we're working on that to see how else we can expand that outreach. But I think we are very well connected connected in terms of connecting students to our services.
Thank you. And then Jenna, one of the rules under the Trump administration and Betsy DeVos is acknowledging due process rights for those accused of sexual assault, and it addresses fundamental fairness, that it's required for accused students have a right to hearing and cross-examination for their accusers. What's your opinion about maintaining protections and rights for those that are accused? Why is this important or not important?
Well, I think the rights apply to both sides, not just the accused. I mean, the accused and the accuser can both attend the hearing, and a lot of times that's just as important to the accuser as it is to the accused. So I think having seen so many of these cases, it is very important to have a hearing and an opportunity for each side to cross-examine each other, to point out the flaws in each other's cases. Previously at Cal State and a lot of other universities in California, a lot of these processes were decided by a single investigator without any hearing. And there was a lot of a lack of accountability, I would say, and a lot of opportunity for the university to kind of side with one person or the other person. And just, it's a toss of a coin at that point. And the individual accuser or the accused isn't really given the process that they deserve and the opportunity to present their case as they should.
Mm-hmm. And California law was ahead of federal regulations, and hearing and cross-examinations became mandatory in 2019. Why do you think California was so ahead of this regulation?
A lot of it was because of me and my firm. Actually, the case, the Dovey Ali case, was our case. And it was a situation against USC where somebody had been falsely accused of sexual assault, of a violent sexual assault. And he appealed his case in the trial court and wasn't successful. He'd been expelled from USC. And then he appealed it to the Court of Appeal, and the Court of Appeal found that in that case, where there was just a single investigator who had reviewed all the evidence, she had exercised questionable, that's what the court used, questionable discretion in reviewing that evidence, and had not investigated possible motives that the complainant may have had to falsify a complaint. She had not looked at the evidence closely and not done the cross-examination or questioning that she should have. And so the court found that a hearing was really necessary to determine the facts of the case.
So I'm going to switch back to Samuel. What was the difference in how a college handled a case under the old rules versus the new rules and regulations?
We've received a lot of questions about what has changed under the new DeVos regulations, which took effect August 14th, 2020 of this year. And first, I can start with what hasn't changed. So CSUN continues to use the preponderance of the evidence standard, which means which is a 51% standard, which story, when considering all the evidence, is the more believable story. Second, CSUN continues to ban all sexual harassment and sexual misconduct by CSUN community members, regardless of where or when that sexual misconduct took place, okay? The DeVos regulations only cover sexual misconduct in the course of educational activities. Our policy is broader than that, and it's allowed to be broader than that. And conduct that does not fall under the Title IX regulations will continue to be investigated under a different procedure, which is our prior procedures. Parties will be informed of what procedure their complaint falls under, and will have an opportunity to appeal that determination. And they'll be informed what the consequences of each procedure are. The differences with the new regulations are that hearing requirements apply to all sexual harassment complaints now, not just sexual misconduct. So we used to only have hearings for sexual assault, rape, groping. Now, hearing requirements apply to all sexual misconduct complaints. Second, hearing requirements apply to all employees, not just students. We used to only have hearings for student-on-student complaints. Now hearings are for all sexual misconduct complaints. Third, there's no early resolution for complaints by students against employees. So if a student claims that a professor sexually assaulted someone, we must have a hearing. There's no way to end it early, and that comes from the federal regulations. And fourth, hearing advisors are required in all hearings. So under the prior rules, a student could choose to attend a hearing by themselves without an advisor who would ask questions and cross-examine. Now, advisors are required, whether or not a student wants one, and we will work to connect all students with advisors, and students will have an opportunity to choose which advisor they'd like, but they must have one, and the advisor is a person who must ask the questions.
In regards to regulations such as the cross-examination of the accuser and the accused, especially being face-to-face, do you guys think that will act as a deterrent for victims to come forward? Danielle, I'll go ahead and start with you.
Thank you. Absolutely. I think it would act as a deterrent for victims to come forward. The process in of itself, reporting, is traumatizing. Before or after these regulations, it's been traumatizing. And I think that now with the new regulations, absolutely due process is important. But I do think it provides a barrier for survivors coming forward with what happened for them or coming forward with an accusation. It also acts as a way for a survivor to maybe not feel comfortable disclosing to different entities on campus, knowing that it may lead to it being reported to the Title IX office, which may make it hard for the survivors to access resources or to know about resources, because the mere act of asking for a resource may then lead that individual to then report to Title IX. And so I do think it provides a big barrier now for survivors.
And then can you talk a little bit about the impact changes like these have over victims?
Of course, I think the impact, other than the barrier itself to reporting, but also the cross-examination, for example, I think that there's still some ways to go in terms of adding more protections to survivors within that cross-examination procedure, especially when it comes to the different types of questions that may be asked of survivors. I think it also impacts a survivor in terms of putting them in a place where they may need now to access maybe legal counsel, because of the fact that the cross-examination really mirrors a legal proceeding, not just an administrative proceeding, that now it may warrant them seeking a legal counsel to represent them at a cross-examination. And so that impacts their accessibility to resources. I think it also impacts a survivor's ability to know how many people can be at the hearing. Can they have more than one support person, for example, at that hearing to feel comfortable in that process? Can they speak eloquently about what's been happening for them in that hearing versus with one-on-one with an investigator, for example? That could also be traumatizing in of itself, to be face-to-face with the respondent. Typically, in the past, they wouldn't necessarily have to be face-to-face with the respondent, and now they may have to be face-to-face with the respondent, and that can be really terrifying to do that. So I think there's some impacts to consider on survivors, at least.
Jenna, I want to ask, how would you respond to students might not being able to have certain access to resources to do a hearing and to go through that whole entire process?
I would say that respondents have been having to hire legal counsel in these processes for many, many years. I mean, these are incredibly serious allegations that a lot of times are criminal allegations. And a student would be remiss if they did not hire an attorney in these sorts of processes. So I completely sympathize with the fact that a lot of accusers will now have to get legal counsel, but these are incredibly serious allegations. I can't stress that enough. And a lot is on the line. And for many years, respondents have had to seek legal counsel and expend hundreds of thousands of dollars sometimes in resources to fight these allegations. So I understand, and I don't think that for either side, it's an ideal situation. And I wish that there were more restorative justice options that could kind of resolve these situations rather than making it adversarial in nature. But that's where we are.
Samuel, how does a school go about changing Title IX regulations, and how are those new rules communicated to students so everybody knows all of their rights, including, the accusers and the accused?
So our office actually does not write our policies. That comes from the Chancellor's office. So the Chancellor's office has reviewed the new regulations carefully over a number of months and has updated the policies in accordance with them. However, our job has been to communicate the major changes to students and faculty, and we've been updating our training and reaching out to various organizations, Greek life, athletics, different clubs on campus to let them know about the new regulations, faculty members. But we've been communicating the major changes which we've discussed today that affect all students, which are that an increased number of claims are now potentially hearing cases, that we are limited in the amount of confidentiality that our office can maintain relating to complaints that come to us, and that hearings have new requirements to them, including the presence of a hearing advisor. But each time a student comes forward to our office with a complaint, we will let the student know in the beginning what process their complaint will likely fall under and what that process will look like before they make the decision to move forward with an investigation, so they know.
As we all know, the election is coming up in just a few days. It's approaching very quickly. And what, if anything, are you anticipating to change or to be affected? Will DeVos's rule be overturned if Trump is not reelected? Jenna, I'm going to go ahead and start with you and let you answer that first.
Yeah, that's an interesting question. And if Biden is elected, I think, or I've read on his platform at least, that he'll try to reinstate the 2011 and possibly the 2014 guidance that were rescinded under the Trump administration. And I noticed also that under the Trump administration, both of those guidance documents rely on a 2001 sexual harassment guidance document, which was also rescinded. The new regulations also, however, rely on that 2001 guidance document. And so everything kind of relates back to that document. The 2011 and the 2014 guidance documents, or their Dear Colleague letter and a Q&A, they don't really provide a lot of guidance to universities about how the proceedings should be conducted, which is kind of how we got into a lot of this mess to begin with, because every university across the country was doing something differently, and every university in California was doing something totally differently. So I think the federal regulations are very helpful in that they provide a uniform policy that everybody can kind of look to and rely on, and know this is what I'm entitled to. This is the process that I am due, accusers and accused alike. If that's repealed, which I don't think that Biden can just simply repeal it because there's no guidance document at the moment to go back on. So I think what Biden would have to do is go through the same note and comment period under the Administrative Procedures Act that the Trump administration went through, which was a 3-year process where they developed these proposed regulations and then opened it up to a note and comment period and had like 120,000 people comment about what they thought the regulations should include. And only then were they able to release these federal regulations. So I think that Biden would have to go through the same process if he wants to change the federal regulations or release new ones. Mm-hmm. So I don't think that he can eliminate them right off the bat.
Danielle and Samuel, I want to open it up to you guys as well. If you are anticipating anything to change, or if you are hoping that something might change with this upcoming election.
I think that that Jenna is correct in that regardless of who is the next president of the United States, the regulations are not going to change for at least the next year. Biden has made it clear that he wants to repeal those regulations, but that will likely involve a notice and comment period. And so the process of repealing them will be a minimum of 1 year, after which time, if they are repealed, we will return to the previous process, which was hearings for student complaints only and hearings only for sexual misconduct.
Danielle, did you have anything to add?
I echo what everyone has shared, that the likelihood that this may be overturned quickly is not that likely. And so it's a process and a regulation that we are adapting to and probably have to continue adapting to.
As this election is approaching, do you think that there's anything that maybe hasn't gotten enough focus in these Title IX regulations that you are hoping changes?
I mean, I'm happy with the regulations as they are. Do I think that the universities are complying with them the way that they should be? That's another question. I think I would prefer that the universities come up with some uniform policy for all misconduct to make it a little bit less complicated for, I mean, as an attorney, it's difficult for me to read through all of the Cal State policies and figure out what's going on, because it's, 80 pages of this type of conduct. And if it's not that, it's under this other policy, and you've got to keep your finger here and then look at this other policy. It'd be a lot more convenient, I think, for everybody, students and faculty and attorneys and advisors alike, if there was a single policy that just provided due process to everyone, which isn't that complicated. I mean, it's, notice of what you're being accused of doing and having a fair opportunity to respond, which I think the courts are pretty clear, and the federal government, that includes some sort of cross-examination.
Samuel, do you have any response to the point that Jenna made?
One thing that everybody can agree on is everybody is looking for more clarity into the investigation process. There have been a lot of changes rapidly in the last 10 years. And so it has been, I think the amount of changes has also deterred complaints because students do not have a strong understanding of what the investigation process looks like. So regardless of what changes are made, I think students are hoping that the changes are simplified and the changes are solidified in some form. I think that there are different policies for a reason, and it's because our office conducts a wide variety of investigations. We don't just review complaints of sexual misconduct like rape. We also investigate complaints of gender expression discrimination, where somebody alleges that their professor isn't using the proper pronoun for them in their classes, national origin discrimination, race discrimination in grades. And to have a hearing officer decide all of those cases with cross-examination is just a much longer process than is likely necessary, and just not realistic for what our university can provide right now. We receive about 550 complaints a year, and just don't have the resources for 550 hearings.
Mm-hmm. Danielle, as far as advocacy for victims, what are ways that you think that these rules and regulations and these policies are able to be better communicated with these students so that they're aware of their rights?
I think that's a great point. It speaks to what Jenna and Sam have spoken about, that the clarity, it lacks a bit of clarity, especially for survivors trying to navigate this process and trying to understand what rights they have and to decide, right? You want to make an informed decision of whether to report, whether or not to report, how to go about something. And I think it really starts with simple things like syllabus, right? This is something that all students have access to. How do we get more information on there on a syllabi? Also doing more outreach we're doing that already, but continuing to do more outreach with different organizations that we can then have them continue to do the outreach as well. So passing on the torch in some ways, because let's be honest, I think a lot of times information is passed more quickly from student to student or faculty to student rather than administrator to student. And so how do we allow that flow of communication to be improved? And to add to the question that you asked previously of Sam and Jenna, I think it's also worth a change in terms of creating a deadline for which these investigations have to be conducted by, both for the respondent and the survivor, because this is a very challenging process. And I think that's also a barrier for survivors wanting to proceed with this, right? It does impact academic success. And so if these proceedings are taking longer than usual, that could also continue to impact their healing journey and their academic success.
Well, I really appreciate all of you for joining us today to talk about something so important to so many people. I really appreciate you guys taking the time to talk about it.
We spoke with a 911 dispatcher about resources that can assist sexual assault victims.
I think there are plenty of resources. Unfortunately, not many people are aware of the resources. And I think maybe PSAs or, it started young when we were children. We used to have those, like, Rainbow Flash NBC, the more you know type of things, where it's just letting the public know, like, hey, you could call non-emergency into any police station and they'll be able to provide you with an advocate. Also, there are specific nationwide organizations, like you could call RAIN or you could call Strength United. It depends on your location, but Strength United is based from CSUN, so it's actually with a partnership with our police department. So every station, police station, sheriff station, CHP station is equipped with an advocate in order to walk you through the process.
Thank you for watching On Point. You can follow us on social media at CSUN On Point. You can hear us on KCSN 88.5 FM on Sunday mornings at 5:30. You can watch us on Santa Clarita Valley Television and on LA 36. For producers Sam Novicki, Sarah Mio, and Sammy Fernandez, and moderator Jessica Vaughan, I'm Brenda Saldana.